My name's Isabelle Teare with the WTJX Newsfeed, and you're watching Trial Watch, where we're covering the trial of the United States of America versus Calvert White and Benjamin Hendricks. And today was another long day of court, and I'm here to break it down with you all. So we left off yesterday with the United States and both defendants, resting their cases. And so what was going to happen today is we were going to dive right into closing arguments presented by both the prosecution and the defense. But before we did that, there were a couple things that needed to happen. The first was something called a charging conference. And this is something that doesn't include the jury. This is, it's in open court. It's between the judge and the attorneys. And this is where they discuss and they finalize the jury instructions, which are going to be read to the jury before they go back to deliberate. So that started at early in the morning and went until about 9:30. And then after that was when we really dove into what everyone wanted to hear, which were the closing arguments. Just a note on what it was like in the courtroom today. It was the busiest I've seen it since the start of this trial, outside of when they were selecting a jury, when all of those potential jurors were filling that gallery. But today, there was someone in each of the benches. It was very busy. And so then the jury enters the courtroom. And the judge who is presiding over this case, Judge Mark Kearney, told the jury that the evidence is done. And he compared it to a puzzle. He said that, you have all of the puzzle pieces now, and it's now your job to put those puzzle pieces together and return a verdict. And after that, we went right into closing arguments, and the United States started. And it was U.S. Attorney Michael Connolly who did the closing arguments for the United States, and he started by thanking the jury for everything they're doing, and he put up a PowerPoint that both the jury could see and those of us watching in the gallery. And before he went into the PowerPoint, he said, "Over the past several days, you've delved deep into the world of greed and corruption." He said that Calvert White was supposed to be working for the people of the Virgin Islands, but his loyalty could be bought for $16,000. And then this is where he referred up to this PowerPoint presentation, and it was the United States running through a timeline of all of the evidence that they've presented throughout this trial. And so I'm not going to go into every single thing they showed, because that would be, doing what we've already done. But I'm just going to walk you through a couple of the main points that were hit. So he started off by describing that first phone call we heard and showing a bit of the transcript from that, where we have David Whitaker and Calvert White on the phone, where Calvert White tells him to get in touch with Benjamin Hendricks. And after Attorney Connolly, referenced the screen and these exhibits, he would then come back, look at the jury, and talk to them about, what that meant on a more personal level, if you will. And he used this moment to really describe Benjamin Hendricks as a middleman, as an accomplice. And he kept using this word throughout his closing argument. He then went on to another piece of evidence, which we've already seen, which is that recording of the interaction between David Whitaker, Benjamin Hendricks, and Calvert White on St. Croix outside of the Carnival Village, where we also saw a video where Calvert White was saying, "You better have a photographic memory," and he's showing David Whitaker that confidential bid information. And it's in this recording where we hear Calvert White say, "I've been doing this a while, and know the less evidence, the better." Michael Connolly then, looked at the jury and said, "Does this sound like someone who's been duped? And then he said, "This sounds like someone who knows exactly what they're doing." And then again, back up to the evidence, and he showed that the recording where Calvert White said it can't be a check, and where they discussed installments, and Calvert White says, "I'll let Benji handle it." And again, Connolly continues referring to Benjamin Hendricks as this middleman. Then another exhibit, the one where we hear Calvert White in a recording say, "I have no doubt SmartNet would have gotten it if I wasn't in this meeting." Again, SmartNet was that other company that was bidding against Monethos for this government contract. We then see some texts between Calvert White and Benjamin Hendricks, where Calvert White said, "Let David know I can't go into this meeting and fight for him unless he settles with me." Again, we've heard all of this before throughout the trial. Some more evidence was put in, and then we got to the end, or we got closer to the end of Michael Connolly's closing argument. And here he said, without referencing any of the PowerPoint, he said, "I want to talk to you about David Whitaker," you meaning the jury. He said, "He's a criminal, a felon, several times over." He said, "David Whitaker is not likable, but you don't have to like him to believe him." Again, this is Michael Connolly speaking directly to the jury. And at this point, he started getting loud and animated. And it was very loud in the courtroom because, keep in mind, these attorneys are mic'd. So when they start, raising their voice, that increases the volume, and it's very loud in the courtroom. And he says, "We don't just believe David Whitaker," meaning, the United States isn't saying just believe David Whitaker. He said, "We demand corroboration. We don't just offer you his testimony. You have the calls, the recordings, the texts, the meetings." And after he said this, he went on to say again, he's still not likable, but his testimony matches the evidence. He then went and started talking about the charges that are levied against these two defendants. And he explained these to the jury. The first charge is a count of honest services wire fraud. And just so you understand, in order for the defendants to be found guilty of this charge, there have to be several elements that are met. In this case, for the count of honest services wire fraud, there are 3 elements, and I'm going to paraphrase those for you. The first is that the defendant knowingly devised or participated in a scheme to defraud the Virgin Islands and its citizens of their right to the honest services of a public official. The second is that the defendant acted with the intent to defraud. And the third is that in advancing this scheme, they transmitted any writing, signal, or sound by means of a wire, radio, or television communication. And we're actually going to come back to that third element a little later on. So then Attorney Michael Connolly went and explained the second count, which is of bribery concerning programs receiving federal funds. This has 5 elements that need to be met. The first is that Calvert White was an agent of the Virgin Islands at the time of the incident. The second is that the Virgin Islands received federal funds in excess of $10,000 in a 1-year period. In other words, the Virgin Islands received more than $10,000 from the federal government in a 1-year time span. The third is that Calvert White accepted, solicited, or demanded something of value from David Whitaker. What that something of value isn't defined. It's just something of value. The fourth is that Calvert White acted corruptly with the intention to be rewarded. And the fifth is that the value of the business transaction or series of transactions was at least $5,000. Okay, sorry about that. I know it's a lot, but I just want you to understand what it is that Attorney Michael Connolly is explaining to the jury. This was the close of his closing arguments. He said that Calvert White should have been fighting for the people of the Virgin Islands, but he said he wasn't. He said Calvert White was fighting for David Whitaker. And then he closed everything out by saying to the jury, "Today we ask you to turn on the lights, to get rid of the shadows. Turn on the lights to see what's happening in the back rooms." And this was the end of Michael Connolly's closing arguments. And we transitioned immediately into the closing arguments of Clive Rivers. And he is once again the attorney representing Calvert White. So he started by thanking the jury, and then he said, I don't have any pretty slides, referring to the slideshow that the United States had presented. He said, I'm not as polished as the United States attorneys. I'm not as eloquent as the United States attorneys. I'm just a country lawyer down in Niskey. And then he dove right into saying that the government wants you, meaning the jury, to look pinpointedly at certain things and ignore other things. He said Calvert White has certain constitutional rights. And then he said this same Constitution wasn't kind to people like him. It didn't consider him a full person, but now it does. And he then started talking about this issue of the recordings, which we've talked about, whether or not they're able to be understood without a transcript. And Clive Rivers said they suggested to you a transcript of what's supposed to be in those recordings, referring to the United States presenting these transcripts and recordings. And Clive Rivers said, I'm from around these parts, and I don't even understand those recordings. So it must give you room for pause. And if that gives you pause, I call that reasonable doubt. He then moved on to talking about the testimony of that witness that the defense called, Julio Reimer, who's the the director of the Office of Management and Budget, or OMB. And Clive Rivers said the amount of the bid was already published on OMB's website 6 months before. That should give you pause. And he went on to say that the United States didn't even check the website. He said, why? Because the United States had on blinders. He said they are thorough when they want to be and woefully inept when they need to be. And once again, all of that had to do with the fact that there was published on the website of the Office of Management and Budget the certain information about the amount that was going to be directed to the Department of Sports, Parks, and Recs, that $1.6 million. So then Clive Rivers also brought up the fact that the United States never presented any evidence extracted from Calvert White's phone. He said they got nothing from his phone. If they had, they would have brought it in here. And just as a side note, I want to remind you of during yesterday's testimony, we heard about the fact that when they had gone in and forensically examined Calvert White's phone, they hadn't found the text messages between Calvert White and Benjamin Hendricks that had been extracted from Benjamin Hendricks' phone. And Clive Rivers then went and closed out his arguments by saying utter disrespect and disdain. That's what he has for the territory and for us, he being David Whitaker. He said, all the evidence is in, they have what they have, they don't have what they don't have, and what they don't have is proof beyond a reasonable doubt. And this is where he closed off his arguments. And so during his arguments, the jury was stern. They were serious. They were pretty attentive. And I want to remind you of something that I said yesterday, how Clive Rivers has a very different manner of speaking and addressing the jury and the courtroom. He's slower. He pauses more. He emphasizes certain words. And this is different from the style of attorney Darren John Baptiste. During Clive Rivers' closing, I also saw a couple people from the jury look into the gallery where Calvert White's family and friends were sitting. And then when attorney Clive Rivers had wrapped up, I saw a couple jurors, 2 women sitting in the back. They looked at each other, they exchanged a few words, and they smiled. We can't know anything they said, just an observation. After that, we moved right into the closing arguments for attorney Darren John Baptiste, who, of course, represents Benjamin Hendricks. And he opened up by saying, we need to keep common sense with us. And he actually put up one of the government exhibits, a transcript, of one of those recordings. And it was a portion of the transcript of the recorded call between Calvert White and David Whitaker, that initial call where Calvert White tells David Whitaker to reach out to Benjamin Hendricks. But what Darren John Baptiste did is he directed the jury's attention to a part of the call that hadn't really been, harped on, if you will, before. And it's the end of that the end of a recording where they start talking about WAPA and lights and cameras going up and things that, were going on with other work that Benjamin Hendricks had going on with David Whitaker. And what Darren John Baptiste was trying to basically get across in this moment was that Benjamin Hendricks was already known to, David Whitaker, that they had a previous relationship, that this wasn't the first time they had all interacted with each other. And after that, he said, common sense says we're missing something. And he actually started kind of shouting at this point. Remember how I said they're mic'd up? It was very loud and almost shocking when he did this. And he said, that's common sense, referring to the fact that these people had known each other previously. He then said that David Whitaker had left a trail of destruction and debt. And actually, sorry, I want to go back very quickly. I missed one little note here, which just is an interesting observation from the courtroom. When Darren John Baptiste got animated and said, that's common sense, very, very loudly, we did see Clive Rivers just kind of start chuckling, sitting in his seat, right there next to defendant Calvert White. Okay, so back to Darren John Baptiste's closing arguments. He said that David Whitaker was going to tell the jury what he thinks they need to hear in order to get himself out of a jam. He said this was his modus operandi. And once again, he got very loud at this point, and he even slammed down a piece of paper on that stand from where he was speaking. And we saw members of the jury chuckle when he did this. Again, very animated, very loud, a different style from Clive Rivers. He then said that Whitaker takes everyone in this courtroom for fools, takes the Virgin Islands for fools. And he asked the jury to return a verdict of not guilty for both of these men. He said, let them get on with their lives. He then went into once again talking about discrediting David Whitaker and calling him a con man. But this was actually a funny moment in the courtroom because by mistake, Attorney Jean Baptiste referred to David Whitaker as Mr. Whitworth. He said Mr. Whitworth is a con man. And Agent Whitworth is actually the FBI special agent who's been investigating this case. So when he did that, the whole courtroom started laughing. All the jurors were laughing. Agent Whitworth was even laughing. And Attorney Darren John Baptiste, or maybe not laughing, but smiling. And then Attorney Darren John Baptiste kind of came over a little bit, apologized. Agent Whitworth put his hands up like this, and everyone moved on from that. Attorney Darren John Baptiste then said, and closed everything out by saying, don't let this man, referring to David Whitaker, don't let this man destroy more lives. And that was the end. That was the end of his closing arguments. But we were going to hear from the United States one more time in their rebuttal. This is because the United States has the burden of proof, and they get to therefore open and close. And the person who led their rebuttal was Alex Dempsey. He's the attorney that we've heard from the most from the prosecution. And he opened up by saying that the defense attorneys were fairly questioning David Whitaker's credibility. But he did what Attorney Michael Connolly had also done. He said, but you don't have to take David Whitaker's word in this case. You see recordings, you see text messages, you see wire confirmations, you see bank statements. He then talked about the idea of, reasonable doubt. He said, doubt based on hunches and speculation is not reasonable doubt. After that, he addressed something that Attorney Darren John Baptiste had brought up in his closing, the fact that, Benjamin Hendricks and David Whitaker and Calvert White had known each other before, this initial interaction of telling him to talk to Benji. And what he said was, of course, David Whitaker and Benjamin Hendricks and Calvert White knew each other. He said, as a public official, you don't solicit a bribe from someone you don't know. That wouldn't make sense. Of course they knew each other. And then this was really where he closed out his rebuttal. It was quick. It was maybe 10 minutes long. And he just looked at the jury and said, the judge is going to give you instructions, review the facts, apply the law. And then he asked the jury to return a verdict of guilty on all counts. Okay, so we are now at the end of closing arguments, and the judge allows everyone, the jurors and those seated in the court, to have a quick 5-minute break. And so we exited the courtroom, and just an observation again, outside the courtroom, on the balcony of the 3rd floor of the district courthouse, I saw Calvert White, his father Celestino White, and then the attorney Clive Rivers. They were standing together, and Celestino White had his arm around Clive Rivers, and they seemed to be in good spirits talking. And then Calvert White and his father separated and went a little further down near the balcony and just chatted amongst themselves for, the remainder of that break. Then everyone was called back into the courtroom, and this was where the judge, Mark Kearney, was going to give the jury those instructions that had been deliberated at the very beginning of the day between the attorneys and the judge. And he started by looking at the jury and saying, the facts were given to you by the witnesses, not the lawyers. He ran through a couple general things with them. He told them that their verdict must be unanimous. Whether guilty or not guilty, they all must agree. And as a note, up until, let me just say this. He said that the jury could not be influenced by public opinion. He said they couldn't let rumors, suspicions, or anything like that influence their decision. And then back to that note I was just trying to say, it's important to understand that up until now, the jury has not been allowed to talk amongst themselves about this case. They've been under a directive that they, by law, cannot discuss this with anyone, both inside and outside the courtroom. So once the judge dismisses them and to deliberate, this is the first time the jurors are going to be able to talk to each other about what they think, their opinions, whether they think they did it or not, if you will. So then we got into certain jury instructions that were obviously what had been discussed earlier in the day. And these are really important for the defense. The judge told the jurors that they were the sole judges of the credibility of a witness. He said, you decide whether you believe them. He told the jurors that if they thought a witness was lying about certain things, the jurors could choose to not believe the rest of their testimony. Now, this is very big for the defense because this is what they've been trying to really hammer this entire case that we've seen this week. The fact that they're saying David Whitaker isn't credible, you can't believe him, all of these kind of things. And this is what the prosecution has been trying to combat by saying David Whitaker is a criminal. We know that. You don't have to believe him, though, because we have the documents, we have the recordings, all of that. The judge then went on to discuss the fact that these recordings that all of these jurors were hearing, he said those recordings were taken lawfully. But a very important note he made was that the transcripts of those recordings are not evidence. He said that the transcripts can only be used by the jury as a guide. He said the jury must rely on what they heard, not what they read. The judge said if they can't understand the recording, you must not rely on the transcript. This is a big deal because as we've discussed and as I've said before, and as Clive Rivers drove home in his closing arguments, some of these recordings are not easily understandable. If you're closing your eyes and you don't have that guide of the transcript, understanding what they're saying is hard. This isn't for all of the recordings. There are several recordings that are crystal clear. You wouldn't even need a transcript. But for the ones that you do need a transcript, for the ones where the transcript is helpful, that's when the defendants are talking outside the Carnival Village on St. Croix, when there's music in the background, all of that kind of stuff. So that was very important for the defense, I think, to get in their instructions to the jury. The judge also instructed the jurors that the defendants had a constitutional right not to testify, and that they could not consider their decision not to testify in their verdict. And then the judge read from a piece of paper for a long time with more jury instructions that were very legally worded, if you will. This took a while, and you could tell people were getting fidgety at this. I saw some of the jurors just, moving around in their seats. A woman in the gallery actually fell asleep at this point, and you heard her snoring. But this did wrap up. And then right before dismissing the jurors, the judge told them that they would have to choose a foreperson. He described this as the kind of manager of the jury. And what this juror was going to be responsible for was, if the jury has questions, the jury foreperson writes it down on a piece of paper, and that note is verbatim taken by the judge and read to the courtroom and discussed by the attorneys and the judge. And an answer is figured out how they're going to deliver it. So that writing that note is the job of the juror foreperson. And then also they're the person who stands up and reads the verdict once that verdict comes in. The judge looked at them. He said, there is no rush. You can take as long as you wish. And then the jury was dismissed for deliberations, and the case is now officially in their hands. And it remains in their hands. But before we get to that, I'm going to tell you about this last thing that happened after the jurors were dismissed. And this was that the defense attorneys, Clive Rivers and Darren John Baptiste, introduced a motion for Rule 29. And what this was them asking the court and asking the judge to dismiss this case on the basis that the government had not met its burden of proof beyond a reasonable doubt. Attorney Lena Pang for the United States was the one who addressed this. She got up and she looked at the judge and said, there's an abundant level of evidence produced in this case. And she asked for the motion to be denied. The judge then ruled on this, and he said, while there is room for interpretation of evidence, he said the United States had met its burden and the motion was denied. So after this, now it's just a matter of waiting. The jury is in deliberation, and everyone is just kind of waiting outside the courtroom, waiting for either the jury to have questions or for the jury to come back and have their verdict. But actually pretty quickly, about 30 minutes after all of this had ended, the jury had their first question. People came back into the courtroom, and the note read verbatim, the jury would like to see all the instructions, meaning the jury would like to see that the instructions in writing. They had previously just been read, and now they wanted to see them in writing. And after a little bit of back and forth, this was agreed upon, and the instructions were given to the jury. Then everyone was dismissed, and now this was a portion where we were waiting around for a couple hours. At this point, we have Calvert White and members of his family, like Celestino White and his mother, waiting on the third floor of the district courthouse. Benny D is there, several other people. At one point I saw Calvert White kind of tucked up on one of the benches, head down, his eyes were closed, he appeared to be sleeping. And then people are waiting. But then a couple hours in, we all of a sudden were directed to go back into the courtroom, and the mood changed. Tension, there was a little bit of tension at this point, because I think a lot of people thought that maybe this is when the verdict was going to be announced. They got a little bit serious, and everyone went in, everyone sat down, but Calvert White was really kind of expressionless. If he was nervous, I couldn't tell. But from where I was sitting, I couldn't see defendant Benjamin Hendricks. The judge then entered the courtroom, and he said that the jury had their second question. And this is what was read verbatim from the note. Please look at page 23 of the jury instructions. What does interstate commerce mean? The jury has decided to end deliberations for today. What time should we return tomorrow? That was the end of the note. So at that moment, people realized that there wasn't going to be a verdict returned today. It was going to be, sometime tomorrow, if not even a day after that. So the judge and the attorneys agreed that 8:30 tomorrow would be a good start time. And then they sat and discussed this idea of the definition of interstate commerce. And if you remember earlier, I talked about the elements of the charges. And so I'm going to flip back to that very quickly. How Michael Connolly, the attorney for the U.S., in his opening arguments, he said that the defendants were charged with one count of honest services wire fraud. And there were those elements of honest services wire fraud. There, in the third one, it discusses interstate commerce. And I'm just going to read this to you. I know it's legalese, if you will, but bear with me so you understand where that comes from. It says, in advancing the scheme, the defendant transmits or caused to be transmitted by means of wire, radio, or television communication in interstate or foreign commerce, any writing, signs, signals, pictures, or sounds for the purpose of executing such scheme or artifice. Whew. Okay, so now we are back to what the judge and the attorneys are trying to decide. And what Judge Mark Kearney said is that what he thought the jury was referring to was, how could it be interstate commerce in the Virgin Islands? The Virgin Islands aren't states. And he said, and read from the law, he said, the law states that interstate commerce also includes all territories or possessions. So at this point, the judge and the attorneys agreed on that definition that would be presented to the jury. And I'm going to read you that definition that was presented. It was, interstate commerce includes commerce between one state, territory, possession, or the District of Columbia and another state, territory, possession, or the District of Columbia. So that definition was given to the jury. And then it was announced that, well, not announced, we already knew this. Then it was just said, okay, we will reconvene tomorrow at 8:30 a.m. The jury will continue their deliberations. So that means that at 8:30, it isn't like anything's going to happen other than now people are just there to wait around and, either hear if the jury has more questions or if they're there to return a verdict. So that was the end of the proceedings today. After that happened, everyone exited the courthouse, and I came right here to do this edition of Trial Watch. But I will be back in the courthouse tomorrow at 8:30 a.m. to wait and to see what the jury has to say. And we'll be back again tomorrow with another edition of Trial Watch. Again, I'm Isabelle Teare for the WTJX Newsfeed. Thanks for joining us tonight. Have a good evening.